Hello and very warm welcome to the Tax Express. Today in this video we are going to discuss a very important landmark judgment on applicability of parallel proceedings by CGST and SGST authorities under section 6(2)(b) and interpretation of various terms used in this section such as same subject matter and initiation of proceedings. So stay tuned till the end of this video if you are looking to get the right answers through this judgment. Let us now begin with the facts of the case in brief. Messrs Armor Security India Limited is a company engaged in providing security services registered with the Delhi GST authorities. They received a show cause notice from the state GST authorities in the month of November 2024 seeking explanations on various grounds such as input tax credit claim, non-reconciliation of turnover with e-way bills, etc. Later, a search was conducted against the company under section 67 by the CGST authorities in January 2025 and thereafter various summons were issued to the company and their directors to seek relevant information and documentary evidence. The company challenged the validity of issuance of summons under section 70 on the ground that summons would amount to parallel proceedings on the same issue in which already SGST authorities have issued SCN. Agreed by the issuance of summons, the company approached the jurisdictional Delhi High Court which rejected the writ of the taxpayer holding that the term any proceeding in section 6(2)(b) does not include a search or investigation. The High Court held that in issuance of summons by the CGST authorities are precursors to formal adjudication proceedings which can be said to be initiated through issuance of SCN only. At the summons stage, section 6(2)(b) does not come into play as the summons stage is only a stage of gathering information and not considered as initiation of proceedings in itself as contemplated by the section. Agreed by the said order, the company moved Supreme Court and argued that initiation of proceedings under section 6(2)(b) should not be limited to issuance of SCN, which should be interpreted to cover summons under section 70 as well. The petitioner argued that the High Court has erred in limiting the scope of section 6(2)(b) to proceedings under section 73 and 74 only, whereas GST is a complete code in itself. Therefore, the term any proceedings should be interpreted in its broader sense. The Honorable Supreme Court heard the rival parties and analyzed the facts of the case. The court held that summons issued under section 70 of the Act does not constitute initiation of proceedings as it is the stage of pre-inquiry and gathering information. The court emphasized that initiation of any proceedings refers to the formal commencement of adjudicatory proceedings through the issuance of a show cause notice. SCN is a mandatory precondition for raising a demand, sets the law in motion concerning liability and marks the commencement of quasi-judicial adjudication. The court went on to add that even search cannot be said to be initiation of proceedings since even after search, the department has to consider whether to move the matter forward by issuing SCN or not. In this judgment, the Honorable Court further elucidated the term same subject matter and held two-fold test to determine as to what constitutes same subject matter. Accordingly, the two-fold test meant that same subject matter will be when the two authorities seek to assess or recover the identical or overlapping liability and or the relief sought is identical. In the present case, the summons alone could not reveal the same subject matter, it could only be ascertained from the SCN. So the key observations and learnings coming out from this particular judgment are: number 1, section 6(2)(b) bars initiation of proceedings on the same subject matter. Number 2, issuance of summons under section 70 does not constitute initiation of proceedings as it is the mere stage of gathering information. Number 3, while audits or scrutiny can be conducted by the assigned tax jurisdiction only, the intelligence-based enforcement actions can be made by either of the authority. Number 4, actions for probing an inquiry or gathering evidence or information do not constitute proceedings under section 6(2)(b). Number 5, initiation of any proceeding refers to the formal commencement of adjudicatory proceedings via a show cause notice, not summons, search or seizure. So these are very important learnings and guidelines coming out from this landmark judgment of the Honorable Supreme Court, which clears the air around the applicability of parallel proceedings under section 6(2)(b). Through this judgment, the court notably laid down the two-fold test for determination of same subject matter by holding that where relief sought is identical or where the authorities have initiated proceedings for assessing or recovery of the identical or overlapping liability. So this judgment is an eye-opener and is indeed a landmark one for both the department and the taxpayers. Thank you very much for staying with me.